Thank you all for joining us for today's presentation on the E-1 Treaty Trader Visa. My name is Dustin Saldarriaga, and I'm an attorney with Scott Legal PC in New York City. A few housekeeping items before we get started. The first is our firm does handle the full spectrum of U.S. immigration issues. So although today's presentation is focused on the E-1 visa, which is a treaty trader or a business temporary business visa. We do handle family-based visa applications. We handle green card applications, temporary visa applications such as student visas, visitor visas, etc. And we also handle litigation should you have a denial or a delayed case. So if you have any questions about U.S. immigration law, any issues, we do hope you'll reach out to us. One thing that we do think makes our firm stand out from other immigration firms is the fact that our firm's founder, Ian Scott, has personally navigated the process. So our firm was started on an E-2 visa, and previously he held a TN visa, an H-1B, an F-1 student visa. So the fact that we have personally navigated the process really does define how we work with our clients. Now, for this presentation, if you do have any questions, please do send those in through either the chat function or the Q&A function on Zoom. I have those open on my screen. I'll probably save questions for the end, but I do plan to get through all of them. The presentation you see on your screen will be shared with you by email after the presentation. Also, in that email you'll get from us after the presentation will be a link where you can sign up for future webinars, as well as a link to our YouTube channel. We are recording this presentation. We do post the full-length webinar on our YouTube channel. On our YouTube channel, you can also find shorter videos, and again, those do run the full, cover the full spectrum of U.S. immigration law. Our webinars, I should also mention, we try to do at least 2 a week, this being one of them. So we do hope that you'll register for future webinars should they be relevant to you. All right, without further ado, let's go ahead and dive in and talk about the E-1 Treaty visa, E-1 Treaty Trader visa. So I've used the word treaty a few times. So the E-1 visa is a treaty trader visa. What does that mean? That means that the United States has signed treaties with dozens of countries around the world. And if you hold a passport from one of these countries that the United States has signed one of these treaties with, then you meet the nationality requirement to apply for an E-1 treaty trader visa. So that is the treaty aspect, is that you need to hold a passport from a treaty country. Now again, there are dozens of treaty countries. You can find a list of them by searching on Google E-1 treaty countries. And you'll find on the U.S. Department of State website a list. Again, there are dozens, and they cover the Americas, Asia, Europe, etc. So do check that out. Now, there are certain countries that are not E-1 treaty countries. Those include Brazil, China, India, so obviously countries with significant populations. If you do have a passport from a country that is not a treaty country with the United States, you can still apply for an E-1 visa, but you would need to apply for citizenship and have a passport from an E-1 treaty country. So typically countries that people will do this for include, there are certain countries in the Caribbean that offer citizenship through investment, as well as in Europe. So that is an option. Now, unfortunately, recently the law did change where you have to actually reside in that country for at least 3 years before you apply, but it is an option if you really are set on getting a treaty visa in the U.S. and your passport is not from an E-1 treaty country. Now, one thing, let's just continue going down our list. The next requirement is that there must be trade. So the first requirement was that you actually hold a passport from an E-1 treaty country. One note on that. You don't have to be born, obviously, in the E-1 treaty country. So as an example, if you were born in China and you naturalized in Canada, for example, then As long as you have that Canadian passport, you meet this nationality requirement. Okay, next requirement, there must be trade. So what this means is that there must actually be trade between your treaty country. You must be operating an enterprise that is engaging in trade between the treaty country, the country that you have a passport from, and the United States. And a majority of the international trade of that enterprise needs to be between the treaty country and the United States. Okay, we'll get into an example of this later, but again, it's fine if you have, for example, a company in, let's say, Argentina, and you are doing a lot of domestic sales. Say you're selling several $1,000,000 domestically in Argentina, and you have a tiny international component, but most of that international trade is with the U.S., that's fine. As long as at least 50% of your international trade is with the U.S., it is okay if you still have a substantial domestic trade in the treaty country. Okay. Now, let's get into a few details in terms of what trade is. Now, trade is the exchange of goods or services. So that means goods or services originate in the treaty country. So let's continue with our example of Argentina. So let's say Argentina is producing a product that your company is selling to the United States. That's a good. So say it's bread. That is a product that is being sold. Could be services as well. So let's say that you have a company in Argentina that is selling consulting services, and it's primarily U.S. citizens who are, or U.S. clients who are purchasing those services. That can also count. Now, the exchange does need to be traceable and identifiable. So what that means is you need documentation that proves ongoing trade. So this would be invoices, purchase orders. If you're shipping goods, it might be customs records, things like that. And next, the trade actually already needs to be in existence at the time you apply for the visa. So the E-1 visa is not a visa meant to help you start trade. The trade actually needs to already be in active because the application does need to include that paperwork proving that the trade is already ongoing. Next, the trade must be substantial. What does this mean? It's really two things. One is frequency of trade, and the other is volume of trade. So what I mean by volume is more the value of each interaction or each transaction. Most important is likely frequency. So if you have a company that does 100 transactions a month, each transaction is a few $1,000s, but you can show that that trade is ongoing and that every month you have those regular transactions, that is going to likely be stronger than, say, one transaction of several $1,000,000 that happens over the course of the year. So the government wants to see regular, frequent transactions of trade between the treaty country and the United States. Now again, trade must be international between the U.S. and the treaty country. It's fine if you have domestic trade within the treaty country. That doesn't take away from the strength of your application, so long as a majority of your international trade is between the treaty country and the U.S. Next, the applicant must be coming to the U.S. to engage in that trade. Okay, so if you get an E-1 visa, it is not a visa that allows unrestricted work authorization. You can't get an E-1 visa for your company in Argentina, come to the U.S. and start working for Starbucks. You need to be coming to the U.S. to actually build that trade. Okay. Finally, the E-1 visa is a temporary visa, what we call a non-immigrant visa. And that means that you do need to show in your application that you intend to return to your home country at the end of your visa. It's not a green card. Now, that being said, the E-1 visa can be renewed indefinitely so long as you and the trade, the enterprise, remain eligible for the visa. So it is fine to renew your E-1 visa. Also, if you do end up becoming eligible for a green card, you can apply for a green card down the road. But the takeaway here is that you cannot enter on an E-1 visa with the intention of pursuing permanent residency in the U.S. It's fine to enter on an E-1 and then your plans change. You get an opportunity to apply for a green card. That is okay. What is not okay is using your E-1 visa, which is a temporary visa, to enter the U.S. and then to pursue permanent residency. So let's talk a little bit more about what is trade. And we already touched on this, but trade is really broadly defined. So it is any item that is commonly traded in international commerce. That's a very broad definition. It can include goods. I mentioned before bread as an example, fabrics, really any tangible item that you can sell, or services. I mentioned consulting services before, but it could also be tax services, marketing services. If you have people in Argentina or in the treaty country who are providing marketing services to clients in the United States, that's provided by people in the treaty country to U.S. clients. So again, how do you prove trade? Documentation is key. So what we would typically do is we would start with the company's tax returns. And the company's tax returns, and again, these could be from the treaty country. That's not a problem. But the tax returns would typically explain the revenue, the sales. We would take that figure. We would work with the client to figure out what proportion is international sales between the treaty country and foreign countries. We'd show the proportion that's sales to U.S. clients. And then for that portion to U.S. clients, we would actually create a spreadsheet that shows all the transactions that make up that trade between the treaty country and the United States. For each of those transactions in the spreadsheet, we'd want to support that with documentation. So that could be, as you see on your screen, invoices, bills of lading, bank statements, so the company's bank statements showing income or revenue coming in from sales, Department of Homeland Security customs documents, as well as, I mentioned before, the company's tax returns. So we start with that spreadsheet that lists out all of the transactions. And from that, we would cite 2 supporting documents showing each transaction. Again, with the goal of showing substantial and ongoing trade. So how much trade is enough? Again, the language that's used in the law is substantial trade. So unfortunately, there's not a clear definition of what substantial trade is, but that is a positive thing, because what that means is that you can make the argument that any amount of trade is substantial. Now, obviously, if trade is extremely low, it's going to be very hard to make that argument, but the door is still open because the law doesn't say you need a certain dollar amount of trade, and therefore, if you're under that, you're barred from applying for the E-1. So because the term is substantial trade, you can make the argument that your trade is substantial. In practice, what we see is, again, numerous trade exchanges between the U.S. and the treaty country over time. That is important. So regular, frequent transactions or exchanges. Next, the trade should be over a minimum of 6 months over the most recent year, and normally would represent amounts that exceed $250,000 a year. So ideally, the amount of trade that your company in the treaty country would be selling, engaging in with the U.S. would be $250,000 per year at least. Next, consulates focus on the volume of trade, so the number of clients and transactions, and the monetary value of transactions. Again, you do want to show both ideally, so it's best to show regular trade and that those transactions are of a significant value. But key here is regular and ongoing trade. So a single transaction that is significant over a year is going to be risky. All right, and you see that in the next bullet. Single transactions, even if worth a couple $1 million, will not be enough. So focus on those regular transactions, regular and ongoing trade. Can a small business qualify for the E-1 visa? Yes, absolutely. A small business can qualify, but again, the key is showing regular, ongoing, numerous transactions over a period of time, even if they're relatively small in value. All right. Once you get the visa, the E-1 visa, you do need to maintain that trade. So you cannot get the E-1 and then trade cease. You're going to have to show that the trade will continue. So at the time you apply, oftentimes we'll include a business plan that shows where the business is going to be, say 5 years in the future, because that's the typical period for which an E-1 visa is granted. And then when you actually renew your E-1 visa, you absolutely are going to need to show that trade has continued before you get that renewed visa. So let's see. Other trade considerations. Must trade already exist at the time you apply for the E-1 visa? Yes. So again, you need to include that documentation in your application showing the trade. If you are in the situation where you haven't yet established trade and you really want to come to the U.S. to build those channels, those connections between the U.S. and the treaty country, the better option is going to be the B-1 business visitor visa. For some countries, nationals are eligible for the visa waiver program, or ESTA, and that's fine. You can use ESTA as a business visitor, but you'd want to come in as a business visitor and engage in those conversations and build those channels. Now, be careful, because the B-1 visa and ESTA, neither of those allows work authorization. So you need to be careful if you're entering on a B-1 or on ESTA not to work in the U.S., okay? Not to actually engage in trade for profit. But that being said, it is okay to use the B-1 or ESTA for what are called permissible business activities, and that includes things like signing commercial leases, signing contracts, interviewing and hiring people. So you can do those things as long as you are not actively selling and working in the U.S., basically selling your labor for profit. So I touched on this next point before, but how much of the trade must be between the U.S. and the treaty country? And this slide really explains it well. At least 50% of the international trade must be between the U.S. and the treaty country. So let's look at this example. There's a company in Spain. It manufactures glass, and it exports that glass to other countries and within Spain. So it sells within Spain, and it exports the glass to other countries as well. The breakdown of sales is as follows. It sells $100,000 of product within Spain. It sells $500,000 of product to the U.S., and it sells $500,000 of product to China. All right, will that satisfy the requirement? It does, because you ignore the domestic sales, meaning the sales within Spain. Okay, you ignore those. You look at the total international sales. So here, U.S. and China is the total international sales. Those total $1 million. So to hit that 50% mark, you need $500,000. This company is doing $500,000 in the U.S., so it just meets that 50% requirement. So you only need 50% of your international trade to be between the treaty country and the U.S. Should I apply at a consulate or through USCIS? So let's take a step back. When you are applying for an E-1 visa, you really have two options. If you are inside the U.S., then you do have those two options. Those two options are apply through USCIS for what's called a change of status. So let's say you're here on an F1 student visa. You studied trade, and you've on the side been developing a company in your home country that does trade, and you've been a passive owner, let's say, and you have a staff in your home country that's doing that. So you want to change from F1 to E-1. You would do that through USCIS. The other option is applying at a consulate. So you would actually leave the U.S., go to the consulate in your home country, and you'd actually get a physical visa in your passport. So those are the two options, consulate or USCIS. USCIS is only an option if you're in the U.S. So if you're outside the U.S., your only option is to apply at a consulate. Okay? So let's assume you're in the U.S., so both options are available to you. Should you apply at a consulate or through USCIS? In general, we recommend that you apply to consulate, and there are a number of reasons for that. First, only consulates can issue a visa. So what does that mean? What do you get from USCIS? Well, USCIS gives you status. So again, USCIS, you file an application to change your status. So going back to my example, if you're a student, you're changing from F1 status to E1 status. If you're approved, you get a new what's called an I-94, and that's a form that says you're in the US and now your status is E1 as of this date. And typically they're going to give you 2 years of E1 status. But the issue with that is that as soon as you leave the US, that goes out the window. You cannot re-enter the US on a change of status approval. You need a visa to do that. So applying through USCIS is fine if you don't plan to leave the US for a while. And then you'll have E1 status, you'll stay in the US for a couple years, and it'll be worthwhile. A consulate, on the other hand, you leave, you have your interview, you get your visa and your passport. You can enter and exit the US as much as you want over the validity period of the visa. And oftentimes the E1 is approved for 5 years. So you have 5 years that you can enter and exit the US. Each time you enter the US, you're usually given 2 years of status. So if you have a 5-year E1 visa and you enter on the last day that visa is valid, you should still get 2 years of status on that visa when you enter on that visa. So a visa really does give a lot of flexibility in terms of the ability to travel, to leave and re-enter the US, and USCIS does not give that. Next, USCIS tends to be more expensive. So there's the filing fee for USCIS. If you want to expedite that application and get a decision within 15 business days, you're going to be paying about $3,000 just to get that quick decision. Compare that to a consulate where the application fee is about $300. So consulates tend to be much cheaper than USCIS. So really, those are the options on the table. For some people, it really does make sense to apply through USCIS. An example where that might make sense, let's go back to our student who's in the US. If that person said, you know what, my home consulate is taking 6 months to grant interviews, so I want to get the USCIS approval in 2 weeks. I want to start building my business, and then I'll go to the consulate, I'll get my visa in 6 months, and then I'll come back in. So if you want to get the business started quickly and you're in the US, a change of status could work well. You'll just have to pay that $3,000 expedite fee. You'll get your E1 status within 2 or 3 weeks. You'll be able to start building the business, and then once your consulate, your home consulate, calls you in for an interview, you'll travel out, get your visa, and come back in on that. So USCIS can make sense there. Also, if you just don't plan to travel and you're okay staying in the US, then a change of status could make sense. Certain countries of nationality, so certain treaty countries, have a shorter reciprocity period. So what that means is the E1 visa is issued for a shorter period of time than other countries. I've mentioned that 5 years is common. While that's true, many countries have shorter validity periods. It could be 2 years, it could be months. So if you do have a shorter validity period on the visa, extending your status through USCIS could also make sense, or changing your status through USCIS could make sense. All right, let's talk a little bit about the business plan and employees and the business entity. So what is a business plan? A business plan is basically a document that you can include in the application that shows, it explains what's going to be sold by the company, or what is being sold by the company, who the customers are, how you're going to market the products or services, and really it shows projections, both personnel projections, how many people you plan to employ, as well as financial projections, the revenue you expect, the profit, the expenses, cash flow, balance sheet. All of these things are typically included in a business plan. So do you need one? The answer is typically for an E1 visa, you do not need a business plan. And there are a few reasons for that. First, the E1 visa, again, is based on existing trade. So it really is backwards looking. It's looking at the trade your company has already done. And if you can show that your company has already done substantial trade, that is what the decision should be based on. Now, If the consulate or USCIS believes that your company is not going to continue engaging in trade, that could really threaten the application. Again, you have to continue trade after the visa is issued. So if that is a risk, if that's a possibility that the government might believe this company's not going to continue trade, then a business plan could be helpful to reinforce the application and show here's how we're going to continue engaging in that trade. But if there's not a reason to think that the business is going to stop trade, so if it's conducted trade in the past, then it makes sense that trade will continue in the future, then a business plan is probably not needed. Also, the E-1 visa does not require that you have any U.S. employees. So this is a big difference, a big contrast with the E-2 visa. The E-2 visa is a treaty investor visa, and the E-2 requires that your company in the U.S. actually hire U.S. employees. The E-1 does not have that requirement. So there's no need in a business plan to show that you'll employ U.S. workers, since that's not a requirement. We would usually recommend a business plan for an E-2 application, and that's because you do have to show the government that you'll employ U.S. workers. Next, the E-1 does not require a lease in the U.S. In fact, you don't even need a U.S. entity. All right, so the E-1 has far fewer requirements than an E-2. You don't even necessarily need a physical presence in the U.S. And why is that? Well, let's think about what a typical business looks like that's engaging in trade. You might have a company in Argentina that has executed a bunch of contracts with companies in the U.S., and all the company in Argentina is doing is shipping those products to the U.S. So you don't necessarily need an entity in the U.S. for that. You can get the E-1 visa, and the purpose of you getting the visa is to grow those connections in the U.S., but you may not need to create a business entity in the U.S. or have a physical presence in the U.S. Okay, but let's talk a little bit more about that a little later. But the next thing I do want to mention is that another requirement you don't have for the E-1 is investment. For the E-2, you do have to invest. The requirement is you must invest a substantial amount. They use that substantial word there, but in the context of investment rather than trade. You don't have to worry about that for the E-1. As long as you have that trade, it doesn't really matter if you've invested your personal funds into the business. The E-1 is really based on that trade. Okay, so a huge benefit and convenience if you qualify for the E-1. And just to take a step back, you're already probably getting this impression, but if someone were to come to us and they have a passport from a country that has both an E-1 and an E-2 treaty, so they could apply for either based on their nationality, and they qualify for both an E-1 and an E-2, they could apply for an E-1 or an E-2, we oftentimes would recommend the E-1. And the recommendation is based on the fact that the requirements for the E-1 are so much lighter than the E-2. Don't need to hire U.S. workers, don't need an office space in the U.S., don't need an investment. It really is far lighter, a much lighter lift than the E-2. Now, I mentioned you don't need a business in the U.S., a business entity in the U.S., and that's because trade will oftentimes be based on the entity abroad. Okay, so the company in Argentina that's selling products to the U.S. as an example. The treaty trader can be an individual, a partnership, a joint venture, or a corporation. Now, that being said, you might strategically create a U.S. entity just to show that this is a legitimate enterprise, it is real, it is operating, it is going to continue engaging in trade. It can help to show that if you have created a limited liability company in the U.S. whose purpose is to facilitate that trade from abroad. But it's not a requirement. That can also be helpful from a tax or liability standpoint. We don't practice tax law, so do talk with your tax attorney or your accountant about that, but we do see in practice that it's oftentimes beneficial to think about that. So what are some common reasons for denial? First of all, this whole application hinges on trade. So if you have infrequent transactions, trade transactions between the U.S. and the treaty country, that's a red flag. If you only have a few clients, that could be a red flag, although frankly, we have seen approvals where there's even one client, but they're buying a lot of the product and they're buying it frequently. If less than 50% of the international trade, if there is less than 50% of international trade between the US and the treaty country, that's going to be a red flag. Again, you need at least 50% trade between the US and the treaty country. Also, if there's no trade at the time you apply, that's going to be a huge risk. The government wants to see that trade is already established and ongoing. And you can show that through contracts, through invoices, etc., the documentation we talked about before. And finally, let's say you get your E-1 visa and you're looking to renew the visa. What do you need to be mindful of? So the first thing is you need to show that trade has continued. So you would look at the period from your last approval, your last E-1 approval, to the time you're applying, and you would do the same thing with the spreadsheet showing trade, with supporting documents showing that trade has been ongoing over the last 5 years or however many years it's been. Trade must continue to be substantial, so regular, frequent, and of a significant volume, ideally. You'd use tax returns, you'd use that spreadsheet I mentioned, invoices and bank statements to show that. Next, you do need to maintain at least 50% of the trade between the treaty country and the US. So don't let the trade drop below that 50% mark after you get your E-1. All right, otherwise you could threaten the E-1, your ability to renew it. Next, always check the website of the consulate where you're applying, because each consulate has its own rules and its own procedures. And they tend to be very strict, so that if you don't follow those strict rules, they may reject your application or deny it. So always check the consulate. Of course, if you work with us on an E-1, that is our job. We always check the consulate's requirements before we prepare an application. And that leads us, I believe we've answered all the questions that have come in, but if there are any others, please do send those in. During our webinars, we don't answer questions that are specific to participants' circumstances. So if you do have any questions, please schedule a consultation with us. We would be more than happy to talk with you. A link to schedule the consultation will be in the email we'll send to you after this presentation. We'd love to talk with you. So with that, please do stay well. Sign up for other webinars. We'd love to see you again, and reach out for a consultation if you have any questions at all. Thank you so much.